Welcome to the Supported Living Property Podcast with your host, me, Lisa Brown, the place to learn about supported living property investing. Hi Eleanor, it's great to have you here today. For people who don't know you, do you want to introduce yourself?
Yes, of course. It's lovely to be invited on. My name is Eleanor Tallon and I am an independent social worker. I'm also an early stage researcher. So I've worked in local authorities for around 16 years. Predominantly latter part of my career, I was working in kind of DOL and DOLS teams, COP DOL as well, MCA teams and safeguarding teams. I then kind of left the local authority to do some independent work. Well, I actually started out by being a private rehabilitation case manager, which I was working with people with acquired brain injuries. And then I decided to set up my own business, MCA Professional, which is basically kind of focused on, I do court protection, expert witness reports, mental capacity assessments as well for the clients of deputies and solicitors. I do a bit of training, some consultancy, and I also do a little bit of independent advocacy as well. So it's quite a mixed bag. And in 2024, last September, I began my master's in social research. So it's actually a funded kind of doctoral training pathway towards a PhD. So it's a stretch of my life going forward, but I'm very excited about it. My research area is looking at the application of the Mental Capacity Act, particularly with people with acquired brain injury. So that's a bit about me.
And that places you so well for what we're talking about today. And I know this is the Supported Living Property Podcast, and people might think, well, why is this relevant to me? But bear with us, because it is very relevant to what we're going to talk about. And we're talking about how we protect people, aren't we? But what would you say, Eleanor, about this? What is the deprivation of liberty, and why is it important?
So I think in terms of when people think about the word deprivation of liberty or DOLs or DOL, COP DOL, whichever, terminology, they're thinking about kind of the legal processes and the legalities of DOL. And I will speak about that, as we move forwards. But I always try to encourage people to think about, the fact that it's about human experience, it's about liberty. And it's about the fact that, people all have the right to liberty and the right to freedom, and it would be the same for anyone, whether you have a cognitive impairment or not. So we all have things that give us meaning to our life. The personal kind of things that help us have a sense of connection and identity. So for me, it might be, I don't know, spending time with my family, doing a bit of yoga, going out with friends, drinks and meals, all of those kind of things that those are things that we take for granted, but obviously if those things were taken away from us, or if we were prevented from doing those things because, we had to be supervised or, we were controlled as part of those things, then we would be absolutely devastated. I mean, I certainly would feel as if life was, hopeless, meaningless to an extent. So we need safeguards in terms of, safeguarding those rights to liberty, and to avoid any kind of arbitrary or unnecessary kind of infringements upon our liberties and our freedoms. So the
Go on.
go on,
I
please
was going to
do.
say, so why would we be taking those away from somebody? In what situations would they be removed from somebody? Because I think someone listening to this might go, well, yeah, that makes perfect sense. Of course, everyone should have the right to do those things, but there are situations where those rights are removed, aren't they?
Yes, there are situations because of, the level of risk. If somebody has, their support needs constitute, certain ways of managing risks and certain, care provision, those, the level of that care can constitute, restrictions can be needed to keep somebody safe. And they have to be, the least restrictive, and and obviously that really is what deprivation of liberty authorization process is about. But certainly kind of go into that a little bit more as we speak. But I just wanted to point out that I guess the starting point in terms of the legality is Article 5 of the European Convention of Human Rights. So that is the kind of, that's the primary kind of overriding legislation, which is, European, and then we have that kind of adopted into our UK law through the Human Rights Act and the Mental Capacity Act. So I won't go through all the history of that. There's a great video that's put together by Dr. Lucy Series and Grace Curry. If you want to kind of see, how the law was developed, why, deprivation of liberty, safeguards are very much necessary, and how it's all kind of transpired and progressed over the years. Great video. So I'll give you that to fit in the links.
Yeah, we'll put that in the show notes for people if you're looking to find that. Yeah.
Yeah. But basically, yeah, so the upshot of it is that under the Mental Capacity Act, a DOL, a deprivation of liberty, can be authorised, but obviously it has to be, the process is that there would be assessments done to look at whether the restrictions were really necessary and really proportionate to the risks of harm. So deprivation of liberty in essence is a sum of maybe a number of, well, it may be just one restriction, a very intense restriction, or it may be a number of restrictions. But a deprivation of liberty is kind of the sum of a number of restrictions, or one restriction that ultimately deprives someone of their liberty. Sorry, it's gone a bit dark in my attic office. The sun's gone in.
What kind of things would be removed from somebody under a deprivation of liberty? Can you give me some examples of the kind of things for people who aren't familiar with them?
Well, I guess, I mean, I wouldn't say that it's not about removing something.
So
I
I've got
guess
the terminology there
yeah,
wrong.
yeah. Well, yeah.
Yeah.
I mean, it's I suppose. Well, I guess it is about removing, because it's about removing freedom, but it's about kind of things that might be put in place, such as a locked door, such as monitoring devices like sensors, sedative medications, restraint, kind of things like, I don't know, bed rails, physical restraints, black belts, all those kind of things. But not only that, things like just being not allowed to go into certain areas of the property or the home, obviously not being able to go out on your own, and or maybe having one-to-one support or two-to-one support, just not being able to make a decision about where you are living, and what what you kind of where you're going to go and what you're going to do on a daily basis, because that is controlled or restricted by those that are providing the care, and obviously the restrictions are often in place for very good reasons, but then sometimes they're not. Sometimes they're not proportionate to the risk of harm. Sometimes restrictions are in place, but actually it's more about making things easier for staff, or making things, so someone might be overly sedated because it makes it easier to care for them, but actually there could be other ways of doing things, like providing more stimulation and sensory sensory kind of stimulation. People might be much more calm if they had certain music or certain lights or certain ways
So it's
of
making sure that there's protections in place so that we're not just sedating people because it's easier for the care team, that actually if we're sedating people, it's because there's justification for that, not just to make life simpler for everybody else.
Yeah, I guess the philosophy, that's the philosophy, in terms of just looking at least restrictive options at all times, and making sure that any restrictions that are in place are not just arbitrary. Just there needs to be full justification and rationale for those things, and that essentially is what the DOL authorization process it is about. It's about kind of, checking, doing those checks and balances, looking at whether, is this least restrictive? Can something else be done that's less restrictive?
Yeah.
It's about, yeah, making sure that that if that, if that absolute kind of infringement upon that person's liberty is really necessary, then it, it has to be justified and reviewed, and and all things considered, to ensure that it's not just a kind of a knee-jerk reaction to somebody
Right.
having maybe behaviors that challenge others. That kind of, it's about looking at what the person actually needs to to live a life which is much more free and fulfilling. Yeah, that should be the mentality. Although I know that sometimes that doesn't come across and people don't see that,
Mm.
or it doesn't kind of it's difficult to make any changes because of lack of resources, and so that so when we are looking at less restrictive options, so as a best interest assessor, for example, I've looked at or been involved in cases where the the options that are on the table, because in terms of less restrictive options, are just so minimal,
Mm.
because of there's a lack of funding for that person, or so it sometimes it does come down to feeling quite it can feel quite frustrating,
Mm.
because the focus should be about really scoping out what can we do to ensure this person has the freedoms that they're entitled to.
Mm.
Yet
Mm.
sometimes it because a care home might be the only option, because that's the only the only funding option, and the funding options are limited, or what have you.
Mm.
And sometimes going to the court protection can can open up more avenues, because the court protection will really scrutinize and kind of question local authorities and things, to make sure that that they that all kind of all stones are unturned, basically. And if a decision is made, kind of it has to be it has to have a rationale, it has to be justified.
And so there's a tight process to go through, isn't there, for a DOL to be in place? And what would, and we refer to it, and there's a lot of wrong terminology around that, which I'm sure we'll come to. But what is that process that needs to be in place there?
So there's two processes, essentially. So I mean, your listeners and audience, I would imagine, are much more focused and familiar with the community DOL, or the
Mm.
court protection DOL process, or DOL order. So that's one process that's through the court of protection, which covers all, well, people from 16 and above, in the community, in terms of if there is a potential DOL, and it needs an authorization, then it would go through the court of protection. But then there's also kind of a different process, called the Deprivation of Liberty Safeguards, or the DOLS framework, which is for people who are in care homes and hospitals,
Oh, okay.
and it's only people that are 18 and above. So there is kind of, I think there's a bit of confusion about these two processes. They get the term DOLS and DOL gets used interchangeably. Or yeah, I mean,
Yeah,
DOLS
it does.
DOLS seem to get the term DOLS seems to be applied to any deprivation of liberty authorization process, but actually DOLS, is just for care homes and hospitals, whereas COP-DOL, or people might call it, I've heard Dolic, and what was the other terminology? I can't remember, but different local authorities might have DIDS, DIDS. That's another one. So
Okay.
so again, that's community DOL, but that's basically the authorization process that goes through the court protection. So I won't go into the DOLS process, because I don't think your listeners would be
No,
very
it's
much
not so
interested.
relevant, I don't think.
No,
No.
so but in terms of the COP DOL process, so that is essentially, I mean, it very much reflects the same process in terms of assessing, whether or not the restrictions in place are necessary and proportionate, reviewing all the care plans, reviewing the risk assessments that are in place, and reviewing the person's mental capacity to make decisions around the arrangements that they're in. So those assessments are done, and then for the COP-DOL process, that those assessments are basically provided to the court. So an application is made to the court, and ultimately a judge will review all the evidence, and will look at whether or not, you know, the restrictions are necessary and proportionate. Whether the person, you know, there might be questions or concerns that the person actually, you know, doesn't lack capacity or has capacity. You know, and the judge, you know, the judge in the court process will kind of identify where, you know, there may be directions made to reduce restrictions if it's felt that actually this isn't necessary, or the, you know, certain aspects of this is, you know, is questionable, and you know, that process can, you know, it can be quite a lengthy process, and I'm sure that
Because it goes backwards and forwards a bit, does it? Yeah.
yeah, which is why I guess, you know, I mean, the best thing to happen really is for all the risk assessments and the care plans to be, you know, to be kind of up to date and thorough, you know, prior to it going through the application process, so that, you know, it avoids, you know, even further delays in terms of, you know,
Right.
and it's not just about avoiding delays in the process, but, you know, obviously risk assessments need to be up to date, and reviews need to be done, and, you know, everything needs to be done thoroughly, so that, you know, we are looking at, you know, being very proactive about, is there less restrictive options, is this restriction needed, is that restriction actually needed, and have we reviewed that, you know. So yeah, so the process is, yeah, the judge would then, if it is necessary and proportionate, the judge would then make an order to authorise the deprivation of liberty, but on the basis that that would then be reviewed, and it's kind of on the I think the maximum amount of time is 12 months time,
Wow. Okay.
although it can be, you know, only it could just be agreed or authorised for a short period of time,
Right.
and, you know, there's, yeah, so
I'd always assumed it was quite a long, you know, it'd be approved for quite a long period of time. So that seems quite short to me. I can understand why it isn't, but from a process of going through it and then having to review that again in 12 months, I imagine that comes around quite quickly for some organizations.
yeah, it does. But I guess, I mean, the initial process of application and authorization can take quite a long time with people. And my understanding is that people in the community have been waiting, you know, some people have been waiting for quite a long time.
Yeah.
You know, some people are obviously the assessments take place quicker, but that might be because they've been prioritized due to, you know, the level of restrictions, and or certainly if somebody's objecting, so if the person's objecting or showing the behavior that kind of represents an objection, then that would hopefully be prioritized by the local authority to do the assessments and to yeah, to proceed with the application,
Right.
which is another kind of you know, something that providers should be aware of, in terms of, you know, if there are deteriorations in the person's presentation, and if there's any kind of, you know, I don't know, complexities in terms of you know, family members becoming more you know, contentious issues, objections
Mm.
from the person or others, that should be passed on to the local authority, who would then, or whoever is, you know, it might not be the local authority in terms of COP-DOL, it might be the ICB that's overseeing the
Mm.
application, depending on the funding. But anyway, yeah, if there's any changes and, you know, issues that come up, that needs to be fed back to the responsible authority, so that the legal, you know, so that it could potentially be prioritized further, because that's how, that should be the way that, you know, I mean, obviously everybody should be prioritized, and that's, you know, ultimately how it should work. But because of the volume of referrals, you know, there will be a prioritization process to look at, you know, those people that are most significantly restricted, or there's, you know, there's the highest kind of contentious issues there.
Right.
So yeah. Yeah.
So from a provider perspective, you're saying it's making sure your care plans and all your risk assessments and everything is up to date, so you're submitting those well.
Oh,
You know,
absolutely. Yeah.
what are there any other advice or tips for providers who are preparing for this process? Because it might be feel a bit of a daunting process, mightn't it, for some?
Well, yeah, obviously, I mean, making sure that your care plans are kind of up to date and and updating with any changes, but also risk assessments, because it's ultimately the risk assessments that the providers produce, it's their evaluation of whether the risks and the restrictions are necessary and proportionate. So it's that's the starting point as to whether or not a DOL is actually required.
Right.
So it some people seem to think that a DOL or a DOL order or a DOLS, it means that the person should be restricted, but that's not how it works. It's the other way around. If the care plan is of a nature, if the person's needs are so high and the risks are, as validate a level of restriction, then that will need to be evidenced in the care plan, the risk assessments. So if that evidence is there and the rationale is there, then that will be reviewed, and then that would then justify the need for an authorization. Obviously, the authorization process will scrutinize as to whether those care plans are actually necessary and proportionate, because that's part of the safeguarding process. But ultimately, it's the care plan and the risk assessments that need to be, that need to be kind of that they're the I would say they're the authority, because obviously it's the order, the court process, or the DOLS process is what gives it the lawful authority.
Mm.
But ultimately the care plan and the person's needs are what constitute whether the DOL is necessary, the DOL order is necessary. So that's the key thing that has to be up to date, comprehensive. Rationales need to be in place, um, and also to review and to make sure that it's about kind of looking at positive risk taking, so looking at whether or not someone, if that restriction is necessary and proportionate, what's the fade out plan? How can that be reduced? It's not just about, oh, the person's got a DOL order now, so we just do that and that's what we do. That's not how it works. It's about
Right.
kind of, the DOL process is really kind of, I think there's a barrister that Ben Troke, he says it's a spotlight rather than a padlock. So and that's a really strong analogy. So it's about, the DOLS process is like shining a spotlight or a magnifying glass to say, well, actually, is this care plan, fair, and is it really needed? And if the provider are not looking at that in the interim, but if there's a review of the DOL order, set or scheduled for 12 months' time. Well, what's the provider doing in those 12 months that show that they're actually following the Mental Capacity Act in terms of the principles of least restriction, and trying to move that person forwards in terms of, being able to have more freedom and liberty, So that's the role of the provider, Um, so yeah, it's looking at fade out plans and positive risk taking. It's looking at, is there a positive behaviour support plan in place, rather than, just kind of having restrictions. Can the person go from two to one support down to one-to-one support? Can there be short periods or short trials of, no supervision for like short periods of time, or reducing observations down from, I don't know, an hour to 2 hourly through the night, all those kind of things. There's just those little steps of
Mm.
trying to, it's just kind of taking all those little steps to try to work towards the person increasing their, you know, their their liberty. But also, is it's not just about looking at the the care plan and the restrictions, trying to reduce restrictions. It's actually about trying to support the person to to be able to decide on those arrangements, in terms of trying to help them to understand, well, why is this care plan needed? What are the risks? How, it might be the person needs some support to educate them about what's going on. It might be they need accessible information or compensatory strategies, with the cognitive, like memory strategies to remember things and to understand why they need this support, or or it might be to do with weighing up the risks, and there might be issues there that I mean, ultimately it might be that they can't be supported entirely to make the decision, or to actually have capacity to decide on those arrangements. But the process, you should be working with someone to support their decision making as far as possible, regardless of if they do lack the capacity. Then that's all the more reason to apply principle two, or support the person to make the decision. And ultimately the reason behind that is that if they can make the decision to decide on their care arrangements, there wouldn't be a deprivation of liberty if they agreed to, if they are agreeing to that, if they can give valid consent, because that's part of the kind of the definition of deprivation of liberty. So it might be worth me just kind of running through with you, quickly, and I won't go into too much detail because I know that it's probably a bit too much. But basically, there's three elements that make up a deprivation of liberty. So I mean, before we start with that, it has to be imputable to the state, and that basically means that the state have knowledge of the deprivation, or have knowledge of the arrangement. So if they have knowledge of the arrangements, then it doesn't matter who's funding, doesn't matter if local authority or the ICB or whoever's not funded, it could be privately funded. But if they have knowledge of those arrangements, that means it's imputable to the state. So that's kind of the starting point of deprivation of liberty. And then it's the three elements.
So it's not just me locking my granny up in a cupboard because I think she's not safe to go out anymore. It becomes it's so that it is that someone's aware of it. Is that whole
Well,
concept?
yeah, and that's the thing, that even just somebody reporting a safeguarding concern about something like that, that would mean that it was imputed. I mean, that would be a safeguarding.
Yeah, of course it would. I'm
Yeah,
being
yeah,
flippant, but so that's
yes,
the
yeah,
first point of it, isn't it? Yeah,
yeah. But
absolutely.
if somebody, as soon as the local authority are aware, or even, I mean, it can, the CQC being involved, that means that those arrangements are imputable to the state. So yeah, so that's one kind of arm of it. But then the other limbs, or the other elements of deprivation of liberty, sorry, there's two other limbs in terms of the objective element, which is basically that, you might have heard of the acid test, which was introduced through the Supreme Court judgment of Cheshire West in 2014. So the acid test is basically, is the person under continuous supervision and control, which basically that doesn't mean they have to be under constant supervision and control. It's continuous means that they may not be, they may have not have direct supervision for a period of time, but actually there's an arrangement that they have to be, they have to return at a certain time. And if they didn't return, then the provider would, go look in, call the police, have them, basically seek to bring that person back. So that would potentially still constitute continuous supervision.
Right. Okay.
So yeah, so it's being clear. So if they're under continuous supervision and control, and if they are not free to leave. So not free to leave doesn't just mean not free to go out the door because the door's locked, because that kind of, well, that comes under continuous supervision and control. That, that's kind of covered in there. But in terms of the not free to leave element, it's about not being free to leave in a permanent sense. So, I myself or you could choose to, you might decide, well, I don't want to live here anymore. I'm going to I'm going to take myself off
Mm.
and move, and I'm going to move in with my friend, Joe,
Yeah.
in the
Yeah.
next in another city. That's what I'm
Mm.
going to do, and that's what I've decided to do. So, but for somebody, in terms of, someone who's supported in these kind of arrangements, but might not have that liberty,
Mm.
and they're not free to leave in that sense. So it's those two things would, you know, constitute the objective kind of
Right.
test of
Hmm.
what are the restrictions in place? How do they meet that threshold? And then the other part of it is that they are unable to decide on the arrangements, or they can't give valid consent. So if you're unable to decide, so you lack capacity to make the decision
Hmm.
on those arrangements, then that would mean that if those three things were met, the imputable to the state, the objective element in terms of continuous supervision and control, not free to leave, and the subjective element, um, not able to make the decision, then that would constitute a deprivation of liberty. But
Right.
it is very complicated, and obviously, there's lots of I mean, there's so many different nuances in terms of different situations and different arrangements. So it is looked at on a case by case basis, but that is ultimately like that's the, that's the guidance, that's the legal guidance that
Mm.
that certainly as a best interest assessor, that's what you would follow, or the courts
Right.
will follow when they're looking at, is this a deprivation of liberty? Um, so yeah, and then if if the person's, needs do meet that threshold, and it's unavoidable, it's necessary and proportionate, then obviously the legal safeguards are that the person would have a formal representative, and they would also have the opportunity to make a direct appeal to the Court of Protection to challenge their
Yeah.
situation.
Yeah.
So those are the safeguards essentially. And obviously, the representative has a formal role. So it's called a Rule 1-2 rep, or Rule 1-2 representative, within the court protection process. And that person's role is to kind of monitor the care plan, to monitor and, review, well, basically check whether or not the person is objecting or showing signs of objection. So it might not be verbal, it might be through their behavior,
Right.
and make a decision as to whether they would need, that an appeal should be made through
Mm.
the Court of Protection, or it
Right.
might be that they request a review, um, or a different process. But their role is really, if somebody is, if it's clear that they are objecting and wanting to apply to the court to challenge the deprivation of their liberty,
Mm.
then the Rule 1-2 rep is the person that needs to proceed and initiate an application. But also, it's not the local authority or their authorities can initiate it, but that they've got a specific role to kind of keep monitoring the person as well.
Hmm.
So that's an important point as well, that, make sure providers need to be aware of who that person is. So, if there's a Rule of 1-2 rep in place, they need to be aware, they need to be included in, if there's best interest decisions that need to be taken kind of, around the care plan, or if there's changes being made to the care plan, so or review processes, make sure that you're consulting and involving the Rule 1-2 rep. And obviously, you
So it's
know,
not just one off just for that period of going to court. It's actually they have an ongoing role to play in supporting.
yes, they do. I mean, it's their kind of they're the eyes, and the voice of the person in terms of,
Mm.
they're monitoring, but also they're going to be speaking and taking, those issues and objections back to the court, and basically, exercising their right to appeal through the Court of Protection if there's a need, if it's necessary to do so, and that's applicable throughout. The person should have a Rule 1-2 rep, throughout the period of the authorization, throughout,
Mm.
that's one of the safeguards. Yeah, I mean, that's ultimately that's the main legal safeguard, really.
Right.
The other safeguards are just the process itself in terms of reviewing and ensuring that all the care plans are inspected and all restrictions are are questioned and reduced where possible.
Mm.
So yeah, but yeah, I think in terms of any other tips and advice, really is that I guess when considering deprivation of liberty, it's not just about it's really about human rights, and it's not just about the person's um, you know, ability to move around. It's about the person's ability to have relationships and to have, to make decisions and have choices and to, experience things in life. So I do think we kind of need to not just bracket kind of just deprivation of liberty in terms of this legal process, but actually think more widely about the person and about what's important to them and how to ensure that they're involved and participating in decisions and how best to be able to support their life so that it can be as fulfilling as possible. So yeah, and the MCA, the basics of the MCA, just applying the basics. So is the you know, is the mental capacity assessments in place that that do follow the legal process, and
Mm.
if the person does lack capacity, is the best interest decisions in place that follow the best interest checklist? So that's involving consulting with others, ensuring the person's wishes and feelings are considered and promoted as part of those decisions, and just full participation as much as possible.
Mm.
Um, and that that will ensure that that yeah, that practice is as good as it can be, and ensure that the relationships remain positive, because I think it is difficult, I think, with the concept of deprivation of liberty. It sounds so draconian, and I guess that's
Mm.
why I mean it felt quite you know good and reassuring that we would have a different name and a different scheme, a different design of the DOL processes under Liberty Protection Safeguards, LPS. So that sounds a bit more, that sounds
It does
nicer,
sound more
doesn't
positive.
it?
Yeah,
Yeah.
absolutely. Yeah.
Yeah. But then that got kind of kicked out of the kicked to the side of the road, really. And the
But
current
that's
government.
not happening now. We're not changing the process.
Well, I guess it's not been confirmed either way, but
Okay.
obviously it's not, the current government have no appetite to to focus on implementation of that.
Right.
However, in some ways, I think there's definitely positives and negatives of what that process could have brought. I don't think it would have been a panacea. Um,
No.
and it could have potentially brought more problems than it solved.
Right.
But ultimately, what we do have, we need to continue to tweak and try to streamline, and yeah, just improve it and yeah, improve it as much as possible. And even like the terminology, we don't necessarily have to use the word doll or deprivation of liberty. If you look at the Mental Capacity Act, it doesn't say, it doesn't, there's no statutory kind of enforcement that we have to call this process doll. It's just that's how it was. I mean, Schedule A1 of the Mental Capacity Act is covers the deprivation of liberty safeguards framework, which is
Mm.
for care homes and hospitals. But there's no real reason why we can't just, call it the liberty safeguards, rather than this deprivation of liberty.
Because
Because
I've had people talk about on a doll and people saying that somebody is on a doll,
yeah,
which I've referred to a
that
lot. And I
really
know that's a bit of a trigger for you, isn't
kind
it?
of boils my blood a little bit.
Why
I,
is that? What's wrong with that?
I think it's just really because it conjures up this idea of this on a doll, like it's almost like on a tag or being,
Mm.
it just it I think it just shows the misconceptions around what deprivation of liberty safeguards and, you know, the COP-DOL process is actually about. Because on a DOL, it sounds as if it's like this thing that the person must be restricted, or, you know, that it's like a mandatory thing that has to happen. Well, it's not. What it does is it says, you know, if the person, it says that this care plan has been scrutinised, and you know, there may be times when this person needs this level of restriction, and that is lawful, but only at the times when it's necessary and it's proportionate. So, you know, in terms of it being kind of on a dole, you know, it's almost like, well, they need to be locked up now and the key needs to be thrown away, and there's that's it now. We don't need to worry about them. It's, you know, it's been validated. The dole order means that, you know, they should be locked up and we don't have to think about that. That's not what that's if, you know, if people are thinking like that, then that's wrong. And if people are, you know, seeing it in that way, then that's wrong, and that's what needs to change. Because, you know, the as soon as we start to think about liberty safeguards as to what they are, liberty safeguards, human liberty safeguards, we have human beings that we, you know, ultimately, because of, you know, issues around their support needs and the risks, you know, they need a level of support, but actually the focus is about their liberty, the safeguarding their liberty and their human rights, and moving them, you know, moving things forward so that, you know, that wherever they're at this moment in time, you know, we need to work with the person, engage with the person and support the person to, you know, to progress and to be able to manage the risks a bit better, maybe themselves, or look at least restrictive options that others can support them with. So yeah, it's really to try to change that mindset of, you know, on a dole. You know, it's like being, I think people maybe get it confused with being sectioned, you know, because
Yeah.
actually
Yeah, yeah, it's used in a similar way, isn't it? Yeah.
yeah, and you know, being sectioned, which is kind of under the Mental Health Act, um, that is actually, you know, that is a mandatory sectioning. That person has to be treated in the place that, you know, in this
Yeah.
ward or wherever, you know, that is a mandatory thing. It's not like it's not a permissive thing. It's like they have to be treated there. That's what the person needs. Whereas, you know, the DOL order or the DOL's authorization is saying that if needed at specific times, they can be, you know, they can be restricted to that level. But ultimately, that needs to be, you know, it needs to be reviewed, and it needs to be necessary and proportionate for that to be in place. And if they don't need it anymore, then it needs to be removed. You know,
Yeah.
you know, and
Yeah.
it's more a case of, yeah, making sure that if it needs to happen, there is a lawfulness, that you know, it is lawful, because it's been fully scrutinized and evaluated, and the person has got a voice and has got representation to ensure that they can appeal, you know, the decisions that might be made in that manner. So yeah,
Thank
I
you,
mean, I'm just
Eleanor.
thinking if there's any other kind of tips or things that I could pass along. But I think, yeah, I think
I think
that's everything. I think
we've
just
covered so much, Eleanor, and I think it's almost like a masterclass in the DOL and the
I
DOL
hope it's not been too much in terms. I mean, I don't know whether your audience
No.
will kind of think, what is this woman going on about? And she
I think for people who need to know this, this is really, really crucial information. And I think it's so relevant to a lot of my audience who do misunderstand this and don't know it. And I think the advice you've shared from your experience has been really, really helpful. So thank you so much for taking the time for coming on today, Eleanor.
no, it's
We'll put
lovely
your
to have
contact
met.
details in the show notes so people can find you if they need to.
I'll pass on
Um,
some other links as well, which might be
Wonderful.
useful. You
That
know,
would be
just
great.
in terms of providers, and yeah, and I think, you know, just making sure that all, you know, all providers do see the relevance of the liberty safeguards rather than the on a dole. Kind of that's just
Yeah.
the takeaway message that I'd like to kind of people to take home. It's not an off switch to people's rights and freedoms at all. It's a way to provide safeguards of human rights, basically.
Wonderful. Thank you so much. Take care. Bye-bye.
Take care. Bye-bye.
Thank you for listening to this episode. If you're finding this content useful, then maybe it's time you join the Supported Living Property Network. If you're not already a member, then let me explain what's included. The network is a unique community of property investors and providers coming together to create quality supported living homes. If you're a property investor, you can list property on our portal for our provider members to see. You can access the demand portal where our providers list where they need property, so you can buy property to order. If you're a provider, you can access the property portal to see where our members have property available for you to lease, and you can list where you need property. We do not charge any additional introduction or sourcing fees. You also get access to our monthly training sessions with industry experts to help you understand supported living property and keep up to date. You get access to our monthly online networking sessions to help you connect with property investors and providers. I've written 2 training courses, one for providers and one for property investors, to help you get started in supported living property. We have a membership area filled with resources that you need, where you can watch the previous training sessions too. You get all of this for only £47.50 plus VAT a month. And because we do not want you to stay unless you think it's incredible value, you can leave at any time. Just give us 14 days notice. Simply go to www.supportedlivingproperty.uk. That's www.supportedlivingproperty.uk to join us now.